Today in court, Jumedi near the Brel and 9 p.m. pepe on the dot. Adom TV Sony Sanso and Adom 106.3 FM and a radio so Asempa 94.7 FM and also a radio so many your say bon so from be today in court and I don't do any sorry a free Jumedi so and the Supreme Court of Ghana assign etnase na and the court need one ruling and a buy a mobekaya enra yaba betena ase e hwe court no argument a councils ni nyina e de etudwa of course almost sign e de tudwa se nyame ya domo a enne court no e de won ruling ebeba on the application for review on court ni decision on the 11th of February mobeka 11th February na court ni decision by say Electoral Commission omoye first respondent decision omu take here say Jane adokwe means nya de ombe frɛ no ama na begina witness box nim no mo kro mu opinion no case bio court no any Electoral Commission adwen petitioners na lawyer for amfo aso enti omo file review of that decision eno na ene court no ehwe etna so nsem bebre na court so ewo Supreme Court na obehwa omu wieye no petitioner na lawyer for assign to just say Omasia file another review application and Oma file stay of proceedings bill and on a Monday and a court ne betrans court net na no so wi a na se bibia ansan ya mamu biu a court ne be she data or mo de one final ruling ebeden ebeba on this petition enti bibia ba bedu sisi a eno no enne ye jemre ne ya hwe ruling a court no de buy and then a review application into instead of 7 judges of the court no mienu eba beka ho ma na 9 to hear the review application koko wie no na 9-0 against the petitioner and ye be consem mu na ya hwe ruling a court ne de buy nioma mo consider ya ansana sa ruling no eba na mo nso matimi atemo ho ase so dem kan be dey your say bonso make us a lawyer Justice Abdullahi ewa ono ye checheni ewo University of Professional Studies one law faculty ewon kran here de bia ono na eboa ye share court nsensem bi ase no and why yemwa bebre lawyer akwa aba na pom to say
yeah obi nyankopon adom
great eda nyame ase papa and the ruling of the court was an interesting ruling said ye mo bebre na ehwe ye no but before say court ebetna no of course eno no ama TV so ama yen hu ba ye te se judge mpanyifo no etu boni beka say they adjourned the case for 2 hours it means say 9:30 and e was anka court e shase ba omo shase be 11 and reason no ene say petitioners na extra court say omma won kwan na omo di omo application for review ekoye no respondents no response how omo so de ba na say affidavit in opposition to sa application no pay no omo nsa kan e na wo so omutimi ehwem kakra nsa na court na atna say lawyer eye bibi amotaye ewo court
ne kremuni ye na ye nya no sene isisi ye no
okay
but no so no because send court we ankasa no niema na ekoso no dasronko kakra ntina ma bibi set me by nti se behwa said the kind na no ye hu no court them in fact by letter
yeah
and a lawyer to letter the comma registrar no
okay
say on fan kodum court say omonsa nka respondents no omo response in term affidavit in opposition
yeah
omonsa nka in fact anadu the zoom
and omonsa
11 near send mu email be 11 to 12 and some mo say anagufado ne electoral commissioner omonso file o manu asem nti emremu no se woni obi nya asem a na se wo kan bibia ono so ho kwan se won so yi ano so yi ano a emra eso ma won so ho kwan se ohun na no yi no
okay
se be ya won so wo bibi ka fa won so aka fa na we na akwa ade bi se jaso nti akwa jaso ne de na se nka eye se bi o case bia nke bia nka yebitimi amamo bia na otwempo na otwe mienu
okay
se mo so mo nkohwem na mo so mo nwene ho
okay
na nka mpokra so nka na nakufado ne electoral commission kra so nka mo so mo mpepere mo ho
entro
for mo no asamo ma samen because mo so be dodo na no wo be nanum
okay
na fo be num a mo so betimi e de adwene ho na so the response bia ba o bia de aba and sakra na de ono so de aba no so ne nsa nka ntama court mi ba na atwe mienu ba we de bibia e jaso enti na akoduru se de akoduru no se ko ba so mo so mo twɛn na ma ba court a no ma be pa court a chawa na ebi ebe ensem tenten wan hwe kra na court ankopene so mpo enti omo fa mse kwan pai so ele ko to court ni se ni se ni akoye enti ampa judge for no so jitu me san se emra mo mo kwan se so mo so hwe mansa no maba enti se ko ba se omo ba no mo ka se mo nhwe mo nsan kan no mo hwe mu nti court mo kwan nka court ebe ji ato nti se we me funi se we mo no ya ade so mutimi ma court aso trentem se ma court nti ba sa judge for no mo ha mo ho se bia sa 2 hours no mo so se bio o medi breakfast mutimi ahome mutimi ahwehwe nka tem kakra ansa no maba nti ebo ma afanu ni nyina no obi anya sa ahomegye no ne se akwanya no e de ye ni odebe because se bio da bia so pa no pa bia by 9 o'clock I saw court there be in fact on daily basis literally and yet market was ye wo ye bia mfa ho wo ba yare o uti na ye wo ye o se bia kwantu bia ye bi kra na akwa se wo jai na ba like so much sacrifice our family including the judges of the court be a sacrifice to ensure the system no e be work to perfection and I think that this time they say bo mu na ba so because mu na ade senka baby a nke bia nke tu sheda mpo nke normal bia nke tu sheda so judge omu nyina agitum se no yen ka ne ya se bi so so hwema unhia san se nyina ya agitum se we special nti no e beta ma 1 or 2 hours
be safa
na so prepare nyamencha de lawyers ni nyina so enye lawyer ba kope ene each side e bia de be 9 num ene eba it is also niti na we aso ne na we aso ne 9 na we aso ne fu ye nyina yen ka mom ye nyina sa nti mi gidi say this time afanu nyina ade
okay nti lawyer Chasuse Kata court no eba betna see eventually at 11 am no omo ma ne kwan say on kasa as lawyer for the petitioner na osase eda court no ase say at that short notice still a court ne ma won kwan say the lawyer aka no ema won be 2 hours be say omonfa enkonkwohwe response a respondent no e de abanimo wie na afio de ne argument akasa why omu free say court no decision on my on the 11th say electoral commission for wo kwan so on because ye case ne yemie na ye witness no kwa yem frɛ ne ma ne magina box nim why a omo ne court ne nya adwen say court ne fo a sansem ne so de tuja owie electoral commission lawyer so e de ne de atudwa why omo so free say the court ne count the 11th na court ne dika sanso e na na do dan kwa kofa the lawyer so e count ne de omo wie court ne break kakra for bare 30 minutes to almost 1 hour and after omo ruling but yentie ruling a president of the panel chief justice of the republic and in yeboa e de tudwa ne bi
submitted that this court in the ruling and the review failed to consider. We have considered the submission on the effect of Section 26 of NRCD 323. We are not persuaded that the issue of statutory estoppel urged on us by the applicant's counsel by reason of not specifically referred to in the ruling and the review renders the ruling per incuriam. We have also taken into consideration the applicant's reliance on Article 19, Clause 13, and 296 of the 1992 Constitution. Yes. We are of the view that the applicant has failed to satisfy the court that new or important matter resulted from the reference to the constitutional provisions referred to. In the result, the application fails and it is hereby dismissed.
The application fails and is hereby dismissed. Sounds very, very familiar. OSHA court way and almost all the interlocutory applications, apart from the very first one, petitioners need to call say on person moko amend your petition, original petition or file on the 30th of December. No, all the other interlocutory applications, no, a court need really unanimous, and Bonica is unanimous, and I just say judges ni nyina adwen ko benkom and they say yeah no nya adwen a omu nyina so omo na wo enya adwen and that has been the case. It started with 7-0 9-0 ba ko ba 7-0 miensa bi aba and 9-0 assign so ababio and the radio so obi edeba say 62-0 against the petitioners. Very interesting, but that's the situation ewo Supreme Court. The mayor sisi ade say ye beda na ye ho akwa we abasisi aye ba lawyer will have to go into the decision properly. Court ne ka say petitioners ne entimi am providing real reason why was a court ne kra invoking a review jurisdiction. Ni nyina ye nsemo a lawyer for na etias nti ye nkwohwe we mra ye ba lawyer beboa ye me yakom. Today in court, so ne wa Adom TV, Asempa FM and Adom FM. Shede and the Supreme Court in some course so the munchiremu amamo ewo dwumedie eso petrosol eboyen almost a clean fuel in full quantities always a delightful experience. Here DBS Roofing, we truly are your roof expert. And your Coa mixture, formerly known as Coa FS, almost the immune booster for your general well-being. A dray here pie was the winner be Nansea COVID, a hard dream, say a month for fee, kuma a month for near, and there was so immune system, no, a very, very, very strong. And Coa mixture, a bebuao, a was aquino, eso. Lawyer, Yemrana, Yemra, can be a Saudi FM. Say Supreme Court a decision be a you say any of the lower courts a high court a decision no any ho a court of appeal. Supreme Court a decision no any ho will be invoking the review jurisdiction of the court no wako review. Now you see wo grounds mienu bia obegina so dey review. Grounds be ansa na ya ba be hwe ene de course.
Obi waka nie na mamen chiremu kakra.
Okay.
And the crisis court nketwa ni bi etike decision which me court akesim no akosesa na Supreme Court etike decision uni bibia kwan bia ni ho bi ema nti Supreme Court etike decision final esi nti nya no crisis Supreme Court take decision utimi esan call mo system.
Okay.
Supreme Court etri no court bia ni ho bi and the Supreme Court na nkasa so any appellate jurisdiction over more decisions.
More decision, okay.
So, na ana confusion is say obi oha olusu case with the Supreme Court and we lawyers are na nyese bio. Olusu na esan say appeal bia ni Supreme Court bia mu nti no. Appeal bia ni after Supreme Court na appeal bia cross ni Supreme Court ho. Enti na nipa no akoye review application.
Okay.
Now what to need appeal no what to need review because a kwan bi ani ho nti say ofa kwan bi so e ma court necessary na adwene but in the cremony review make I said the first application petitioner in this case the buy no Supreme Court for no SS sa asema me be kan su dia say review enya appeal.
Okay.
Nti enya time idea review no enya sa amre no na ase wo de ba be appeal because do na no sa na lawyer for do na ye sa appeal na wo ba eno no free court kitwam na e ba Supreme Court ho Supreme Court de onya kasa se pani dware wi a nsu asa Supreme Court kasa eno na appeal bi ani ba bia bi sa wo so wo ba for reviewer eno de asem foforo na wo ba beka eno no nsam bia wo beka ne bi ni sen wo pesa wo kire Supreme Court say emra no o man hyada anhwe ni ye sanse mrani bi bo baabi a se nkomu hu ya
nke bia omo decision
no nkomu enka na sa now this takes into consideration the fact say Supreme Court for no say bi omo ye nipa say judge for no ye nipa say nti bet member say bibi o mrani ba ko bi ho a na mienu bi ho a em se jama ho peprenti ana say bibi nti no ma hu nti the mo decision say mo si ma no but I no nya appeal. Say appeal, I bet my appeal even on based on facts.
Okay. Okay.
And I bet my appeal even based on law. Say judge for no take a decision. O man run asset. Into no man decision say man to court of appeal and also Supreme Court. No mon chere emranu ye. So but Supreme Court the end there. Bibia say anyhow. So man run asset. Nemo be betima ba say emra ba ko bi hye tokrobim akọ bi hye tokrobim ba bia e bia mokra tama mokra mo ka asam mokra ma adwena amaso omo so na ye se bio judge for mpanifo mo wiase omo so e bia bibi nti no omo so omo nyina adwene free so enti upese o chim se o se nko mo hu sa amra na na ye se so ahwe a eno kra na nko wie se sa amra na o ka so mo ahwe no se nko mo hu ya nka decision ebe sesa
na zo mo hu nti no o mo bu ntenchia e de atia o
sa ene ya na miscarriage of justice
okay
parce que koba se o ma hu no se nko mo hu ikra nka en sesa decision na untimi nko for review in other words am pass o ma hu
yeah
but se nko mo hu impokra we de men sabro for ibi en sesa hwe we dey perfect teach my south north yellow teach my baby e ka ho sense sa untimi nko review so na almost kan bi da bia almost studio in fact I think say some kai abra na chief justice watch ya dia sa some dey here pa sa the difference between in fact on mafasa difference between friends saying review and appeal no and some sa judge for the mienu
omotai
here omo papa sa so mu nyina achira dia law school
okay
enti nyankopon cha de omo chira made enti ade atambia enkoma asema de oma no so omo hwe mu books title mafasa book o atwa sansem kriya waka o tra de bia o be kan ho asem judgment omo manyina rulings omo manyina omo san repeat sansem no it sounds there's always that fine line tambia either people deliberately abuse and say people with no choice would definitely have to take advantage of the circumstances.
Yes.
And you know the BBA timisi. And nitiawa so also co reviewer enkoba say we enough grounds. Sa grounds no say court nitia o message on not on the facts but on the law.
On the law.
So na see afanu mu ye mu case omu nyina obia competent lawyers enough ntinya ya ese ne betu omfo but so utie judges ne nsem na mo kana na akwaya se ase emra no a ese nkomu gina so ba for review no enye no mu gina so ba anu nti atam bia ya yes ya bagu bibia yes ya bagu
not just based on the two review applications that you so far no satisfying condition number 1 say emre bi wo ha judges na ehu enu ntino mu di wo intenchia
thank you
and I watch your madwen say bibi sa nim
sa omo pese mo kire say so far
omo hu bibi asa
petition no intimi kire bibi asa omo intimi kire tiawa omo intimi kire say Supreme Court opa kan ordinary bro for one mistake bia e wo mranim
okay
it is a mistake bia dia dey tin say sansan adwene so say the Supreme Court and some rulings in na in fact sometimes even subtly other rulings in the references are made so because you convince you otia say odwene ho na say otia na say de ompeso mo kira na say ase enyina so a wo mremu e say ogina so de ba no ya kwaye say petitioners na ba omu mfa say enyina so ne mma consistently sana Supreme Court worker whether it is a review application or an ordinary application consistently the Supreme Court no with you man you mo kan sa
but na me share omo affidavit in support and review application no so what are grounds for review now for example number 1 or say the ruling of the court in respect of first respondent not being called to testify was per incurium. Per incurium just say na mistake okay. Per incurium, Section 26 of the Evidence Act 1975 and has occasioned a grave miscarriage of justice to the applicant.
Absolutely.
As a court na anhwe Section 26 of the Evidence Act.
Thank you.
Na say wanhwe as a bibi omahu and afi no maka kire won. The other no maka say they've not satisfied that condition.
Nti na make say So who tie judges na brofo no de wa twere ne say oso man hwe wo de waka so man hwe waka say ampa o man hwe nti no nsem no man ni ye waka na emom kiremu ne nti a wo say ya nhwe ne ya hwe nti no ye ni asem ni ye nkiremu no na Supreme Court for no person which say wa nkirem
okay
so sabio ukoshia baby na so be wa na so do no na so do na so kirem die nti a do na o si oh say be ma de say mitimi do ba nti na me do sabio me nyini se wo kra na yo sa ba na be pene sa ware no so nti utie Supreme Court sa na umpe so mo kire
26 na ye hu no e kwan me na no fa so
nti wo gina so aka se no nti ye ni asem
ni ye okay you have to establish a link
sa no umpe so oka nti je say wo ba no abaka wo be kan keke se ya nhwe okay ebi ampa ya nhwe a bit ma say no cream you hear ruling now baby en why you can section 26 one sem a bit ma say in fact there's no even implied AB interpretation or reference to section 26 in Wasem. But how did that amount to a miscarriage of justice?
Now, I am a practice, say lawyer be jina court him. Na lawyer ni make legal point be to support the case. Say court need your ruling a bar. I also want to address all the legal points a lawyer ni raise. Yense.
Ni kremuni. Dear di woman say judge or no woman decision no. On e kire di ehia no.
Okay.
Sansemu ye face bi da bia. O court e bi okra not just on the law. O court o could make strong argument on the facts and on the law.
Yeah.
Obia va lawyer for bia mo tie kire mo hwem na e bi okra na obia bone se obia bone se na bia fa pen. Hey chale lawyer we good. Ni e twro. Akwa itemra. Yeah, try. Oh, which one out 3 years then now? I feel na woman more better to na ka. This is in the banana. I said once na ka ndi I said Jamaluma nyumbi na beto e. Ye nti obia. Na nsam ya kan sam ne basa na judge no school no ankwa na say mra na wo kan no ante ase na ne say
the law is in the bosom
but of the final authority. Won't ase ya. Kosoro nyansafo honum.
Because again, was that grounds number 2 no? And okay say grounds A and B will be argued together. And no sure in a chachujina nice or kasano oka sa 2 grounds ne ebomu. B ne ye or say the ruling of the court was in fundamental error in failing to appreciate how the crucial constitutional role of the chairperson of the first respondent necessitated her being called upon to testify and has occasioned a grave miscarriage of justice to the applicant. Into you still at that point about say, is in a year, Juma be a constitution, is your nye, into your pill on pill. It was so Babekasa.
No, a day is in na kobe. Me ya, me kana, ya kwese. I said, that particular argument, any submission of mine, they say almost a rehash
of the earlier
submissions. So, Kobane I cannot pretend to be better than Fanunina, but at least in the minds of the judges, unka sem fufuru bia nti enya oden. Enyum kro na beto ye na ye boguye no. Sa anyum kro ya na wo sen to a kire ye. Won so so aba enim se yensen adwene. Na wo ba enim se yensen adwene na asem kro na kan na asem beka. Ka asem fufuru bia nti wo fi se si etia e bia mpa beto ya soma me asen adwene. This is the mind of the judges. Nemu bana se beto nyum kro na. In fact, obehwa lawyer Justin Amenuvo.
Yeah.
E ka asem na ya. So and some back and one can some for back crowd. Brofo crowd man's sano.
Yeah.
And he say man's some brofo, man's some mra, man's some can. That's a reviewer, but now by the same. This is according to the first respondent's lawyer.
First respondent lawyer.
And said the young lady can I tell you now. Say a review now about a review. There are grounds.
Grounds need 2 pay. And
you don't know so bana betrim. How it affects you and how it affects the total conduct of the matter. Maybe judges no etina o masesa o madwene. But Say ko ba se wo ba na se obeto nwom kro na amenu me ne nya adwene onema bebre ho. Nanso ni o kan no judges for nigetum say ampa won kan asam foforo bia.
Akoto
pa de no ase asam no kra.
2 grounds.
One you na so ne on kan brofo ba ko kra. Mintimi hu se brofo no na em se ye twero me ensa pe na ma nti em se oba eno nko an obeka. Won kan foforo bia nkan wono ni obi ani asam ho no. Oba ono se bio oba nti se de wo free law school foforo ba na we practice here. Ukuta o law enti law no nko an na beka because wo ankasa tri na bibia che de ni. Nti no wo kan mra wi a brofo na kan nya bibia nkan wo bi utira nya na se judge ni bisa asam foforo bia fa ne yakoso no ho a wan hwe asam beba. It looks like the mindset of Akoto Ampa no sa no so ba obe. Oba emra ne sesen emra si we na eso oye we na eso oye brofo a petition no obeka ni nyina no e fa no ho ana se mfa ho no
Kids
so ba hwa Akoto Ampa won spend more than 10 minutes as for many vokra de en camp kra
on 5 minutes
oh sorry agina ho na so wotna se but of course I can understand because petitioner no e na so die da no so kese ono na so convince court no say ampa so se wadwene san say if he say niam aye no anye ni ye nti eden
ma yen home so na men komra me ba sisi there is another review application.
Absolutely.
16th February court made another ruling by this time no for the petitioner to reopen their case and subpoena Jean Mensah and also court ne san ibogui petitioner ne say or say file a review of that ruling Monday or more so yeba yebekọ eno mo sisi ayeba. Today in court, our Adom TV, Media Saibon Su Femi Obi, Mene lawyer Justice Abdullahi, and Waha Eshe, and the Supreme Court in Semi, of course, Yibubum now so wetimi ato ho ase, Nyame Adom, in Yumekobi na so na se adwumedie yetumi de bremo de bia Supreme Court ebetena bia Petrosol, clean fuel in full quantity is always a delightful experience. DBS Roofing, we truly are your roof expert, and a Koa mixture in Canania from Koa FS, the immune booster for your general well-being. Omunyina boy ne edwumedie ebremo. Enti ye ruling in the court no at the buyer it was clear, and so far we ba beka ho a na say be 10 me kind Adom online report bi o my it was a fantastic reporter team no online team no just chronicling all the interlocutory applications are aba and how are ruling no ekoi said them they can catch them no so we first application to amend the petition now and no Supreme Court unanimously edge to mo say petition and betimi amend it that na 7-0 if free hono all the other applications reviewer abam so far ene de ka ho emienu ni nyina 9090 uyi no free ho a be 4 bi aba ni nyina nso ye 70 to ka bibia bomu a we are looking at close to be 10 interlocutory applications ba akopɛ ne kɔma petitioners no de aka nyina ɛkɔ ɛde etia won
well Obi sorry but technically there was a second application petitioners never near
okay
and that is in respect of calling a third witness.
Yeah, third witness. No, okay.
That oral application is also much as friends in chambers and the oral application. It doesn't mean say it wasn't an application.
Yeah.
It was an oral application and it went in their favor.
And also echo in our favor.
Technically, there are two friends and applications are I think that the entire amount for one can have some is because formal application first of all. Yeah. Formal. And second answer, I'm open court. Intina, people overlook that one.
Yeah, it's true. But so far, no, there are 2 more applications. Monday court in the earth. Now, so back we review of 16th February court in the ruling said, yeah, mamo kwai mamu miemu case ne bi ona mo ntonsa Jean Mensah. Petitioner ne say enon so no. So mo hwe interpretation a court ne to section 26 of the Evidence Act na. Again, that decision was also per incurium, not just a mistake be by a occasion a grave injustice, miscarriage of justice to them into one person court they sign a mobile. Lawyer, again, the same benchmarks. Also, meet two conditions, no, and send a court net me as a son again.
Unfortunately, Bibian should answer sign. I'm here, you got to the same song and probably return with the same chorus and then I had the same beat. And you have to answer some Korea, some Hanumsi. And I keep saying why I'm here because the judges no concluding remarks are. On which they must say, Uncle Pom boy, Dwada Yaba, the ABCB, no move to Asha, no mama judgment.
You better date judgment.
In fact, we made say, and a man for chemistry, and I send you in summer, Dr. Yinika and send a yampa, say, because Adia in Yanka cry, who say, what catch him say, oh, because she did my judgment. They say, the ever can be a no, and Gusiaga. Well, I can understand that kind of feeling, but I think, say, it is a wrong interpretation of a judgment, I mean, comment now, and now others now, Supreme Court judges in mind, because I think, say, it is to the effect, say, the music has a mobile Monday, no measure date for judgment, means, say, the ABCB in between, would not affect
the day for judgment.
The day for judgment. I think that is a better way of understanding.
Because I'm also interested, because I actually date for judgment, it will stop party from filing any
application. But what it means is, within that period, whilst preparing for their judgment, if said the whatever affects the ultimate decision, of course they would take that into consideration and it will reflect as well. And more so, application be in interim application. So it might not, and advisedly, it might not, because it has a possibility of reopening your case and leading further evidence. They are now fresh evidence, they are adducing fresh evidence. Then, of course, it could affect the final decisions.
Date.
But maybe only an interim order, and that will not operate to affect the final decision of the court.
Lawyer,
let's take it from that angle.
Okay, your final point bear on motion for stay of proceedings, no?
Sure.
And then court need decide say you moot because review application on my carry.
Absolutely.
And petition and court net so must file back so attached to review application on Monday. And your friend is saying safeguard be said they be your mom file your final submission now. Well, they've not done it.
Yeah, and nothing sans okay, nothing lawyer could power. And in fact, I think just now for class so another tumbi. Say it's a court no bo munkaye. In fact, I think say more of just now maneuver. Say court no more petitioners than kai say. Omonoma comply with the orders of the court. Oma file o manu asemewi. Nemremu no kai say omono petitioners no kan kai say omo file.
File first.
But omono ase omo ejina more applications no more filing so to friends and disobey the orders of the court. So justice anemia boa.
Yeah.
Ebo sans agree because and sakra no be we na sam kan odi kan catch the petitioners and say ompo so mo file because omo there's no stands. Enti omuntimi and hide behind all these applications to avoid filing. Into omo de omo kan ache omo file o omo file o edwada omo be sheda am judgment. Into I think we should take it from that angle to understand say regardless of what the CIA and the petitioners would wish to do. It looks like we are closer to the end
of this petition
drama.
Wow. Lawyer Justice Abdullah and I'm going to Justin Amenuvo. I know you're Justin Amenuvo. Justice Abdullah, a law lecturer at the University of Professional Studies Law Faculty in Cry. I'm in your say bonsu from EOB, host of Today in Court, and after you could see saying it was 94.7. My neighbor for Nasi or Petrosol, clean fuel in full quantities always a delightful experience. DBS Roofing, we truly are your roof expert and Akoa mixture, the immune booster for your general well-being. Nyame Adom court na yakwaje na home aba Monday yi yenso yebeje ya home nyame Adom Monday yebese aba betena na de yebekoso Monday no yasan de mu nchiremu abremu nti nyame nshira mo se mo koso a ehwe yen etie yen e radio so We'll see you on Monday. Good night.